We are obviously assembled here by way of Zoom to hear oral arguments in the case of City of Medina, ex-rel Ralph Jocke versus the City of Medina. On behalf of the appellant, we have Ms. Patricia Walker, and on behalf of the City of Medina, we have Mr. Greg Huber. Ms. Walker, do you wish to reserve any rebuttal time?
Yes, Your Honor, I'd like to reserve 5 minutes, please.
All right, and at the 10-minute mark, I'll let you know that you have arrived at that point, and you can make a decision at that point whether you wish to continue on or to reserve the remainder of your time for rebuttal. With that said, I note that Judges Walbaum and Hall are also present via Zoom, and I believe we are ready to begin. So, Ms. Walker, at your convenience, you may begin.
Thank you. May it please the court, I represent the taxpayers, the appellants. The issue today is whether two ordinances of the City of Medina are valid. Both spent money for the city to pay for the joint city-county courthouse. The case was brought pursuant to RC 733.56, which is the taxpayer lawsuit statute for injunctions if the city misapplies funds, abuses corporate power, or executes and performs a contract in contravention of law and ordinance. The taxpayers believe that the city did all three of those. There are three major issues. First, the trial court found that there is only 30 days to contest an ordinance. Second, that both ordinances violate the laws. The trial court found that Ordinance 98-19 did not violate any laws. And third, Ordinance 49-20, which was not discussed by the trial court, even though it was part of the pleadings in the case. The first major issue is that the trial court found that after 30 days, you cannot challenge an ordinance. It cited the case of City of Youngstown versus Aiello, which is a 1951 Ohio Supreme Court case that the taxpayers believe is not appropriate. There are a number of cases that find that you can challenge an ordinance after 30 days. For instance, this court State ex-rel Sunset Properties versus Village of Lodi, in which there was a 1987 ordinance that was challenged in 2011, and the Ohio Supreme Court found in 2015 that the ordinance was partially unconstitutional.
Ms. Walker, let me ask you this, and this is Judge Tucker. What role, if any, does the emergency status of the initial legislation, how does that play into your argument?
In this case, because it is an emergency, there are a number of factors such as the charter that apply. The charter says that an emergency ordinance can only be brought, cannot be brought if there is a joint exercise of powers or a surrender of powers to another entity. So here there is a problem. Also, an emergency ordinance under some case law cannot be challenged by a referendum. And the trial court found the only way that the taxpayers could challenge this ordinance was by a referendum.
Well, let me ask you this. If this was not an ordinance, the initial ordinance, if it was not validly enacted as an emergency ordinance, did it not become final and binding after 30 days? When there was no lawsuit brought to challenge the ordinance by referendum?
That is what the trial court found. However, there is a state statute that says that you can challenge a municipal contract up to 1 year, and that's 733.60. And in this case, the backbones of the ordinances are a contract with the county, between the county and the city. So therefore, that statute that was enacted in 1953, 2 years after the Aiello case was decided, controls.
Thank you.
So other than the issues that we brought up, Ordinance 98-18 did not exist in full when council passed it. There were the two contracts, they were before the public. However, the ordinance was not written when city council passed it. So we believe that the ordinance violated the charter. As I said, the charter only does not allow an emergency ordinance if it surrenders the powers of the city or jointly exercises the power, 2 state statutes and 5 ordinances of the city of Medina. To show that it was a joint exercise of a power, the title of the ordinance itself says it's a joint construction and management of a county city courthouse. Also, the agreement in the ordinance says it's the joint construction and management of a county city courthouse. And the mayor admitted in the deposition that the contract in the ordinances were for the costs of professional design, planning, and construction management services to prepare detailed design specifications for the joint construction of a new combined county city courthouse. Further, not only did the ordinance violate that portion of the charter, but it also violated the surrender of a power of the city. There were no statutory steps taken by the city to hire the architect. There were no statutory steps taken by the city to hire the construction services manager. There was no city contract with either the architect or the construction services manager. The contract with the architect was with the county, and a later contract with the construction services manager was also with the county. The county.
Ms. Walker, let me ask you this, and let's assume for a moment all of that is correct. What relief do you think we can render in this matter?
The taxpayers believe that the court can find the 2 ordinances invalid. The city can then go back and do it correctly and authorize the same amount of money. One of the big issues in this case is that the city needs to comply with the law. And it took a year for the appeal. And in the future, this would be authoritative for the city, telling the city basically that they need to follow their ordinances and the state statutes and follow the procedures that have been set forth.
If the city did that, would that legislation then be subject to a referendum?
Well, it depends. I would assume the city would not pass it by emergency, and then it could be subject to a referendum, yes.
Right.
So the state statutes that the ordinance violated are RC 153.61. The trial court found that it was not a contract for construction. However, it is clearly a contract for the planning for construction. The contract itself says that it would set forth detailed plans for the construction, and planning is part of construction. And it appears that the few cases that have looked at that statute would agree that planning would be part of construction, and therefore the only way the city could put money into a building it didn't own would be by complying with RC 153.61. Secondly, the city did not comply with RC 731.17. That's the statute that requires to read the ordinance 3 times by title or in full. And the city's contention is that they have their own ordinance that supplants that. However, the city did not comply with that ordinance either. The ordinance that the 98-18 did not comply with were the ones that indicated that if the ordinance was not written at the time it was passed by a council committee, the committee chairman would need to review it. That did not happen. The city admits that it did not happen. The ordinance was not available for the members of council 72 hours ahead of time. And the
Ms. Walker, if this were not an emergency ordinance, wouldn't all of those complaints be subject to referendum?
Referendum is whether or not this ordinance should be repealed. And I would think that that could be one of the arguments, but a referendum itself doesn't generally say that it violates these ordinances, particular ordinances. And the only way these are not just rules of council, they are ordinances, they're passed like ordinances, they are in the codified ordinances. We believe that it's important for the city to follow its own laws.
And you have now reached the 10-minute mark, so you can decide if you wish to continue on or reserve the remainder of your time.
Thank you. I think it's more important that I leave my 5 minutes to counter anything that the city has said. I have discussed most of my argument. Thank you.
Thank you, Ms. Walker. Mr. Huber.
Hey, please the court. My name is Greg Huber. I represent the city of Medina in this case. This complaint was filed by the appellants, essentially arguing that statute or ordinance 98-19 is invalid because it was passed on an emergency basis. The ordinance was brought to the city council through the finance committee discussions in June of 2019 twice. In June 10th, the ordinance was considered by the finance committee and asked to be placed upon the agenda for council. On June 24th, the issue of paying for the costs associated with this ordinance was again on the finance committee and then voted out of finance committee to the full council meeting that evening. Now, the ordinance.
Excuse me, were the ordinances in writing at the time so that council could consider them in writing, or was it just verbal?
Yes, on June 24th, the ordinance just simply authorizes the mayor authority to sign the contract. The contract was a part of the finance committee discussion on June 10th and June 24th. And then right after the second discussion went to council meeting, they considered it, they passed it on an emergency basis. And the argument is that they can't pass it on an emergency basis because it constitutes a sharing of power. Now, the city of Medina has had a problem with its municipal court for a long time. And this ordinance just authorized the expenditure of money for hiring an architect to consider the feasibility of joining with the county for a joint courthouse project. It doesn't authorize the construction. There was no plan. It's just simply determining, is it doable? Is it feasible? Is it cost prohibitive? It does not bind the city to moving forward with a new joint courthouse project. And on that basis, I don't believe that this ordinance rises to the level of sharing powers with another entity. And so on that point, I don't think that the charter provision was violated by passing this on an emergency basis. Moreover, the city council voted on this unanimously after discussions at two different meetings. The city council is its own entity. It's its own brain. It considered the matter, it passed it, and what it does is hire the same architect that the county hired in order to consider the feasibility of moving forward. Now, I don't know if at this point, this whole case is essentially moot, because after we passed this ordinance, Pat Walker and her husband and the other fellow who's the plaintiff in this case, Mr. Racy, organized a referendum and passed a referendum that required the city of Medina to not spend any more money until the issue is put again before the voter. And at that point, then the city stopped this contract and has not moved forward. The city then itself put a referendum on this year, asking the voter to approve putting the Medina Municipal Court into the old Common Pleas Court building rather than entering into a joint construction meeting, which referendum did pass. And so the plan for the city of Medina.
And Mr. Huber, I'm going to ask you this: all that does seem to be accurate based upon what we have been able to glean outside the record, but none of this is part of our record. So how do we deal with that?
Well, I'm not sure. I wasn't sure. It's the fact of the situation. I don't think that the passage of Ordinance 9819 was inappropriate in this case on an emergency basis. Moreover, I think the ILO case and some of its progeny clearly require that if you're going to attack the passage of an ordinance on an emergency basis, you have to follow revised code 731.29 and put a referendum on within 30 days attacking the emergency clause.
But there is a lot of case law out there that seems to indicate that in most cases, if an ordinance is passed as an emergency, it is not subject to attack by referendum.
Well, it depends upon what your referendum is. In this case, the appellants chose to present to the voter a referendum concerning the overall idea of a joint courthouse and never brought up the question of the emergency clause. And by operation of law, if the 30 days passes with no challenge, the ordinance becomes valid. And so I don't see any invalidity of this ordinance in terms of the process that occurred. Moreover, there's case law that suggests that even if we didn't exactly follow our own procedure, that still doesn't make an ordinance that's voted upon by a majority of a council invalid. In this case, I don't believe any of the arguments presented by the appellant make ordinance 731 or 98-19 invalid. I guess you have some choices as to how you want to proceed with a referendum. In this case, the appellants did not challenge the issue as to the emergency clause passage until they filed suit in October of 2019. And I think Judge McMonagle appropriately found that, well, choices were made here, the time ran out, and at this point, it's at least as far as the validity of the ordinance itself, it is valid. That's what the trial judge found. Now, ultimately, I don't know how, unless we supplement the record to address the mootness issue, I'm fine with the court reviewing the process and deciding this case just on the record. I only bring it up because I'm not sure when the Judge Tucker asked about what remedy, I'm not sure what remedy this court would provide in light of the current situation. We're not proceeding with this ordinance as it stands. At this point in time, if the court does rule on the validity of the ordinance, I would ask the court to look at the charter. There is not a whole lot of definition provided as to sharing powers. From this side of the aisle, this process did not rise to the level of sharing powers. If this court tells us we were incorrect, then this ordinance shouldn't have been passed by an emergency measure. How do you fix the emergency measure? That gets us into the ILO progeny and its case law and its directive. And essentially, if it's the emergency clause that's incorrectly utilized, there has to be some challenge brought within 30 days. That didn't happen. and the appellants in this case are out of time for challenging this ordinance on that basis. As far as the other arguments presented by the appellants, none of those arguments make this ordinance invalid per the case law that I cited in the briefs that I filed. So we would ask for some direction from the court. Glad to have it. I think everybody in this case has attempted to do as best they can with the situation, and I appreciate the time that's being taken to look at this.
It sounds like you are have finished your presentation. I take it there are no further questions. So, Mr. Huber, thank you. We'll turn it back to Ms. Walker, and you have approximately 5 minutes for rebuttal.
Thank you. On the issue of whether or not the ordinance was written, there was an admission, and it said the complete ordinance 98-19 was not included in any council packet and was not made publicly available or announced on the city's website before or on June 24th, 2019. The response of the city was admit, with the proviso that the agreement with the architect, Brandstetter Carroll, and the agreement for construction manager services was placed on the Medina City Council agenda on June 10th, 2019, and was approved at that time. So what the city admitted was that the ordinance was not written, which means the first 2 pages of ordinance 98-18 were not in front of the public until after council passed ordinance 98-18, and that was admitted by the city. The 2 contracts that are attached to the 2 pages, that is the actual ordinance, the exhibits, those did exist prior to the city passing it. On the issue of whether or not this is a construction contract, the contract itself says that it is for the preparation of detailed design specifications for the joint construction of a combined courthouse. And that, we believe, is actual construction. It said that it would design specific specifications for the courthouse. Further, the contract itself said that the city could renege on the contract. It basically said if the city wanted to get out of the contract, the city could get out of the contract by just telling the county. And it's my understanding that the city has not told the county that they wanted to get out of the contract.
Ms. Walker, I have 2 questions. One is, can we take notice of the fact that there's a referendum that has been passed affecting this entire situation, number 1? And number 2, if we do that, how would you respond to Mr. Huber's argument that this entire case might be moot?
I'd like to take the second part first on the moot. I believe that it is important to get some type of resolution on the issues of whether or not the procedures followed by the city are valid. On the other issue, it's much more complex, and actually it is in court on the issue of the actual what the November 3rd vote, which was an initiative that said that the city could not spend any money on the putting construction into the county courthouse square. That was passed by 8,000 votes. And then the city put an initiative on the ballot that had a different language that said that they could go ahead, but the language is different than the initiative that had been passed. That was passed on May 4th. There were 1,262 people who voted on it. It passed only by 103 votes, but it did not have the same language as the other initiative. And therefore, this court would need to review the language of the 2 initiatives to determine what actually did happen. I believe that these ordinances can be decided, this case can be decided on the 2 ordinances themselves on whether or not they are valid. They involve about $171,000 for the design services. And I think it can be segregated because I think the other issues are not before this court.
But all right. So you don't think we can take judicial notice of these subsequent elections?
I believe that the court may take judicial notice. Obviously, it's up to the court whether or not it wants to take judicial notice. However, I believe that if the court does take judicial notice, the court would need to look at the language of both the initiative that was passed in 2020 and the language of the initiative that was passed in 2021 to determine the whole context. And I believe that that may be beyond what information the court currently has in front of it.
Thank you.
All right, since you had some questions, I'll give you about a minute to sum up.
Thank you. The taxpayers believe that the city did not correctly enact the ordinances and believes that they should be invalidated because there was not sufficient public notice. Even if you look at this, the ordinance itself was not available. And we believe that 2 pages of the city ordinance are valuable and the public should look at it and be able to read it and find out what it says. Further, the ordinance was not on the city's website for 53 days thereafter. There was not enough public notice. We appreciate this court reviewing this issue. Thank you.
Thank you, and we thank you both. We will obviously take the matter under advisement. We will issue a decision as quickly as we can. And other than that, again, thank you. And each of you have a good remainder of your day. Thank you.
Thank you.
Thank you very much.